Welcome to Ideas of India, where we examine academic ideas that can propel India forward. My name is Shruti Rajagopalan, and I'm a senior research fellow at the Mercatus Center at George Mason University. Today, my guest is Saurabh Kirpal. He's a senior advocate at the Delhi High Court and the author of 15 Judgments, Cases That Shaped India's Financial Landscape, and the editor of the anthology titled Sex and the Supreme Court. We discuss the constitutionality of marriage equality that is currently under consideration at the Supreme Court of India, the evolution of jurisprudence governing heterosexual marriage in India, whether the recognition of non-heterosexual marriage requires a uniform civil code, India's Fabian mindset in both personal and economic law, the role of the state, and much more. For a full transcript of this conversation, including helpful links of all the references mentioned, click the link in the show notes or visit discoursemagazine.com. Hi Saurabh, welcome to the show. It's a pleasure to have you here. I'm very excited to pick your brain on a whole host of topics.
Thanks for having me, Shruti. I'm quite looking forward to A, answering your questions, and B, not making too much of a fool of myself after that.
I think you're fishing for compliments right at the head of the conversation, Saurabh. You can be rest assured all those compliments are already conveyed. I want to start at where one can find the root of the constitutional violation in the marriage equality case, because I think it really matters for what kinds of remedies follow from that. If I look at Johar, Nalsa and Puttaswamy, it's very well established that right to freedom of expression under 19(1)(a) and the right to dignity and privacy under 21, those two protections are extremely well established. My question is more about Article 14 and or 15. And in Navtej Johar, Justice Malhotra, while discussing the violations in 14, 15, 19 and 21, she specifically said about Section 377 with respect to Article 14, and now I quote, "It creates an artificial dichotomy. The natural or innate sexual orientation of a person cannot be a ground for discrimination. Where a legislation discriminates on a basis of an intrinsic and core trait of an individual, it cannot form a reasonable classification based on an intelligible differentia." End quote. This was a little bit different from how the now Chief Justice Chandrachud thought about the problem. And again, I quote, he said, "Equating the content of equality with the reasonableness of a classification on which a law is based advances the cause of legal formalism." End quote. What he did was he read in 14 with 15 to provide a more substantive protection against discrimination. So the thing I really want to pick your brain on is the question of reasonable classification versus the protection under discrimination. Because if we go by Justice Indu Malhotra's reasoning and root it in 14, and there is, according to her, no reasonable basis for the classification between heterosexual and non-heterosexual couples, and a 14 violation is so fundamental that it will now invalidate or at least open up to questioning all of the 160 laws that Solicitor General Tushar Mehta argued would be impacted by the process of bringing in marriage equality. And so it's not just a question of remedy under Special Marriage Act or Foreign Marriage Act, which is one kind of remedy. But if we go with the discrimination aspect, then the understanding is there's a basis for reasonable classification, but if it is discriminatory, then you need to provide protections and read in or read up Special Marriage Act and Foreign Marriage Act. So sorry for the very big lead up. I wanted to pick your brain on where you are on this fundamental question, and then we can work out the remedies that follow.
I think this goes to the heart of our jurisprudence and the heart of how you read the interaction really between Article 14 and 15. And what is the current understanding of those articles. And in that, I must say, I am more in tune with the views of Justice Chandrachud. There is no other way of reading, I think, Article 15 and 14 harmoniously, other than recognizing and taking some part of what Justice Malhotra said, which is those characteristics which are innate to a human being. They imbue Article 15 with a sense of who that article is targeted and directed at. The words caste, race, etc. in Article 15
yes,
all refer to innate characteristics. Of course, it also refers to religion, which is not innate, but nevertheless, It is so fundamental to the choice of the life of a person that it is almost innate. That's point one. And second, it is innate in a sense that very few people go about choosing their religions, right? If you are born the child of a Hindu, you are going to stay a Hindu. If you are born the child of a Muslim, you will stay a Muslim. So while technically it is not innate, it is in practice virtually innate. So there is this set of human facets which are covered by the special provision of Article 15. And I think it's probably better for us to focus on Article 15 for the purpose of the marriage equality case. I suppose the very term marriage equality hides in itself what is it that we are arguing. The idea that we seek parity. And parity implies non-discrimination. And non-discrimination stems really from Article 15. Because my worry is that the classical test of Article 14, so oft repeated of reasonable classification, intelligible differentia, can prove itself to be so formalistic that it can be very easily, of course, complied with. But if you go the other extreme and hold that the classification is itself not reasonable and rational, I think it runs a coach and horse through our constitutional jurisprudence. Often, of course, judges don't seem to mind that. Often, judges don't even seem to be aware that they're doing that. And that is some of the problem that one has with reading some of these judgments. The neat distinction between Article 14 and 15, the awareness as to the applicable test that you are making in the two sections, of course, two provisions to articles is different, is not seen. So I would be a person who leans really in the form of towards Article 15. A non-formalistic reading of Article 15 is possible without touching the rigors of Article or having to comply with Article 14. Of course, there is law which also suggests that 15 is a species of Article 14. And we can discuss that else at some point. If that be the case, then you start to wonder really why have 15 if 14 is a parent and the genus and the species argument. So really there is something unique about Article 15, which also even Justice Indu Malhotra's judgment in Johar does touch upon. When it says that sexuality is included as sex for the purposes of discrimination under Article 15. Now, if 14 is a broad article under which something is to be tested, then there is really no reason for to conflate sexuality into sex. That only happens when you are independently applying an Article 15 test. That's when it becomes necessary. So I think an Article 15 test is a good test to apply. And there we can break ourselves free from this formalistic, two-pronged, traditional Tendolkar test of Article 14. So those rather easily fulfill two criteria we don't need to worry about. We therefore then go into the larger domain of a non-discrimination aspect of Article 15, which is, of course, the impact, which is something that Article 14 need not examine. So Article 15 will go into that. Now, the idea of to test non-discrimination is how does failure to recognize marriage between a non-heterosexual couple impact their life? Right? Now, that is something that may not traditionally fall within the domain of Article 14, not without doing some violence to former jurisprudence. Now, of course, I also have a problem with the former jurisprudence because I think when Article 14 tests were adopted, they were adopted without much thought about the full implications by a court which was relatively at that point of time formalistic. The test of Article 14 was given by a court which decided Gopalan. And the idea that all these fundamental rights are in silos. So the conception of fundamental rights and Part 3 of the Constitution was quite different. So really we were taking with a test that was formulated at a time when rights were viewed very differently and we're still running with it. Now either we can just dump that test but that I think is going to be very difficult for people to do. So wedded as they are to this idea, which is taught to people in classrooms from age 18 onwards, that maybe it's an easier way to take the Article 15 route out and apply that to the marriage equality case and say that see the impact on the lives of us, really. And then, of course, in that comes the proportionality arguments and the whole other set of arguments that can possibly come in by virtue of an Article 15 analysis, unbound that it is as it is with the traditional Article 14 analysis. So all these tests can be then seen similar to the Anuj Garg, the first great expansionist idea of what non-formal equality and Article 15 means. And so many scholars have talked about the liberating influence of Anuj Garg. How those two judges, frankly, I'm not even sure were fully aware of what they have been said to have done in that judgment as has been ascribed to that judgment. And that's part of our retrofitting of our academic argument to legal reasoning. Just the way a judge often retrofits their legal reasoning in past precedent, I sometimes think academic writing in India will take a judgment and feed those judgments into a concept that they already have, whether or not it fits in, partly because of the sheer number of judgments that are delivered. For any, and that's of course something again we can discuss about. There's for every proposition you can find a whole rainbow, and that's rather appropriate. We recorded this in June in Pride Month, and talking of rainbows, there's a rainbow of opinion. Now that's great for an academic or great for a lawyer to prove their point. It's not so good for certainty of the law.
No, and I think adding to that is also the opinions that individual judges are writing have become one extremely lengthy and sometimes incomprehensible. But the other thing is, the reason I think academics interpret and retrofit is also, it's no longer clear what is obiter in a judgment and in whose opinion. So I think this conflation is on purpose been done by various judges across all benches because they want the convenience of being able to pull something out of a past judgment and use it in a later court. But for very many reasons it's a little bit of a mess. So if we take the case of marriage as it currently is in the case of heterosexual couples, now when we think about the age of marriage, 18 for women versus 21 for men, the argument is it passes the 14 test because there's a reasonable basis to classify men and women separately when it comes to age of marriage. This is partly based on custom, it is based on reproductive age, but also some of the specific goals which can be intelligently ascribed to the development goals of the state of what's the age of marriage and the age of the first child and so on. But it will not fail the 15 test because it is not discriminatory. Whereas in the case of non-heterosexual couples, for instance, if we say that 14 is not the right test, or in terms of, if we say that there is a basis for reasonable classification, and now you come to 15, but Special Marriage Act, Foreign Marriage Act are all discriminatory, and therefore you need to read them up, as the case may be. So that's how I interpret what logically follows from what you're saying, that this is going to be a much more specific remedy that is both being sought by the petitioners, maybe not all petitioners, but most petitioners, and what you think is the reasonable expectation from the court.
Yeah, of course, when you argue a matter in court, as we did this marriage equality matter, is while yes, the fulcrum may be Article 15, because it's very difficult to argue about a set of legal relationships in the vacuum. We can't invoke Article 21 like a mantra and say, please create for us something which otherwise has unspecific and unspecified contours, i.e. marriage. So therefore, really practically, also it makes sense as a lawyer to argue for the fact that here is one legally recognized institution. Please use Article 15 and say there is access to a set of people who are arbitrarily excluded from that particular class, and hence there is discrimination on the ground of sex. And therefore, I think it makes sense really to make an Article 15 argument, because then you can sought to be included. Now, of course, we would not want to limit ourselves to an Article 15 argument for the same reason as I said, that there may be instances where there's violation under the common law or in custom, etc., where there is no law in force. And therefore, we may have to rely on Article 21 to then say that please create something. For instance, a spousal visa regime, etc. Now, we don't know whether there is actually no law really. There is, of course, a law which says you can get a visa, not get a visa. There are regulations. Who knows what those regulations are. They're often put in the drawer of a person. And there's so much arbitrariness in all of this. So I would say that's almost a regime without any regulations. So for that, we may need to rely on Article 21 to give in substantive purpose to the right of equality, so that the idea of marriage becomes it's almost an enabling provision rather than a provision that first gives the impetus to it. And I think we've become so used to think of Article 21 as a Kamadhenu, as the cow that gives everything, the celestial cow that gives rise to all rights. And there is a certain amount of intellectual laziness also that comes with that, is that when all else fails, mention Article 21. So I think the two-step process I envisage in future litigation in concerning marriage equality, and of course beyond towards rights of queer couples, would be the idea of the recognition of the institution of marriage between a non-heterosexual couple on a non-discriminatory manner vis-a-vis a heterosexual couple under the Special Marriage Act, and then using that concept, that broader framework, on a case-by-case basis. And I'm a great votary of case-by-case basis expansion of the law.
Yes.
On other areas, and certain aspects of certain other rights will shone differently. And then let's deal with that as and when that arrives. The marriage equality case, I think, largely is about equality. And that's how I think the
Yeah.
debate ought to have been framed. It largely was, but of course, in the flurry of arguments, people are entitled to put all their points of view. Let's see what the judgment comes, what it says.
One implication of this is we are going to end up in a case by case situation, and there's nothing wrong with that conceptually, which is once there is marriage equality, there are going to be all sorts of questions that pop up about succession, about status in a Hindu undivided family, about adoption, and all of those things are governed under personal law, right? So now what takes precedence? Is it the individual's personal faith? What about exogamous marriages? And I understand that it's going to open a huge, I think there's going to be a deluge before the court, and they'll have to navigate that as any court must. But I think the crux of it, as I see it, is that there are two ways to think about the LGBTQ community, right? So one is, if you think about it in the Special Marriage Act sense, we say, you know what, this is one other kind of exogamous marriage, because the Special Marriage Act was really one about exogamy. And all endogamous marriages, we just revert, the default is personal law. Now, the problem with saying that LGBTQ unions are going to be exogamous in nature is that they are also people who simultaneously live in society, who also have freedom of religion, who are part of certain faiths, who are part of certain castes and custom. How does one think about that? Because the Special Marriage Act for exogamous marriages for heterosexual couples was actually quite straightforward. I know there were kinks in the system, but it was straightforward in the sense that the personal customary law does not make room for this union, and it would be discriminatory to not allow that union. So that's what we do. But then they exited that system. So what is a way to think about this? Is the LGBTQ community a fifth community with its own custom that won't evolve through social pressures, but through judicial evolution? And that's another group. Like we have Hindus, we have Muslims, now we have LGBTQ, right? So is that the way to think about it? And this particular community is going to be rooted in individual rights, consent, choice, whereas the other communities which are endogamous are going to be rooted in a more faith-based approach. So I know this is an unfair question, but to me, conceptually, that's the crux of it. And you also allude to this in the book.
See, one part, of course, Special Marriage Act did also concern itself, at least to some extent, with endogamous marriage, which is the Sagotra marriages, right?
Yes.
So it's not entirely correct to say that's only exogamous marriages that it concerns itself with. But I would ask myself the question as to where the division or distinction in Article 15 lie for the queer community. To see a distinction on the basis of sex is different from seeing a distinction on the basis of religion. Now, and this is something that my thoughts have developed maybe during the hearing itself, etc. And there are multiple axes on which Article 15 violations can take place. So I would simply say the easier task would be is not to see the LGBT community or the queer community as a separate group outside the issue of personal law. But there is no reason why the personal law of the same two queer people cannot carry on applying the way it does in a heterosexual union. So if two men get married who are both Hindus, technically the law can still apply in that particular manner. And that might just be an easier way to go about things rather than upsetting too many apple carts in one go. So this is just, of course, a legal, but also a strategic kind of a move, is to say that you can, and also one that doesn't do too much violence to the language of the act. And the people who are during the hearing keen on just saying you can interpret this particular provision when it applies to heterosexual people in one particular manner. And while I may want that because the idea of consent and individuality, etc., may appeal to me as a moral precept, but given the fact that I am a votary also of some semblance of having the language of the statute complied with or followed, I think we can't have such a situation without doing tremendous violence to the language of the statute. But so an easier way to reconcile, of course, all of this is to see the queer community as another two set of people, individuals, who are now asking for equality on the basis of their sexuality or gender and the ability to get marriage. And the realm of personal law is something distinct from that. And if any reform is called for in that, that will apply across the board. So I really believe that's how I would see that the queer community is different but the same. Or as we say in colloquial Hindi, same but different.
No, this brings me back to the Indu Malhotra question, because to me, I understand that really flips the cart. But the simplest way for me to think about it is that you say that there is no basis for reasonable classification, which means in all personal law and Special Marriage Act and Foreign Marriage Act, you're going to basically read in husband or wife as spouse. Right? And instead of man and woman, you're going to read in persons. And then that solves the problem. So you revert to personal law when you revert to personal law. And there's, of course, a Special Marriage Act where you register cases, which you rightly pointed out is true in some cases of endogamous marriages also. But to me, that seems like the most sensible, clean way. Of course, it creates a lot of confusion across 160 statutes because human beings have to interpret it. And there are registrars all over the country who have to interpret it. But isn't that then the cleanest way out, which also puts a stop to all the other crazy, like constantly going back to court and so on?
Look, when you say an Article 14 test and the classic sense, that there will be certain provisions of certain different acts where that classification would be reasonable and hence not violative of Article 14. And there would be provisions where that classification is bad. So it's not as though when you apply the Article 15 test, you've shown Article 14 the door. The point is that it still does exist. And for instance, in the Special Marriage Act, you may not need to apply Article 14 to allow a recognition of marriage equality, but there may be certain other provisions where Article 14 will apply. There may also be provisions where you want special protection for women as a class, and you do not want that protection to extend to men. Now, if you do away with the classification or permit and say this classification of queer is, now you'd have to ask yourself, how do the person identify themselves, all other kinds of things. So the moment you do away with the classification, then those gender-specific laws are also potentially under challenge. And that may not always be a good thing. So, for instance, in Domestic Violence Act, you may then render those provisions which are beneficial to solely women on the gendered basis as slightly vulnerable to challenge under Article 14. So I just advise caution on that. And then that's why I'm saying, see it on a case-by-case basis. What is the purpose of that particular act? And then adopt the challenge. Because I don't believe that classification on the basis of gender is something that can never be adopted, or sex, or can never be adopted. It can be. And the moment you rely on Article 14 and you start with the precept that you can never use this classification, then a lot of the special protections of women, something I worry about how it will then be.
And increasingly transgender also, right? Women and transgender since NALSA and the new statute. So I'll tell you what my worry is if we go on a case-by-case basis. And again, this is something you've alluded to in the book. My worry is that with the courts, simply because of the way our courts function, they take on a lot of cases. A lot of them are 2 or 3 judge benches. A 5-judge bench is not typical, and constitution benches larger than 5 are increasingly rare. So I keep worrying about things like kaushal, right? Where you take 1 step forward and you take 3 steps back. And this is, of course, kaushal, if we think about it, was just, at least the way I think about it, was just a natural consequence of diluting standing, right? If you say anyone can approach the court, then anyone will approach the court. And then you're going to have a slight problem with how this is navigated. So my worry with doing this on a case-by-case basis is twofold. One, the gains that are made on a case-by-case basis can also be lost on a case-by-case basis. So that's part one of the problem. Second is what you've talked about a fair bit in your other book, the book on financial judgments, which is just causing, like, there's no certainty in the law. And these are matters of everyday life. These are very important questions. Many have important financial implications in terms of property and succession. There is a question of children who are either born outside the union and adopted or born within the union. So these things are going to start getting quite complicated. And these are the areas where we really don't want uncertainty to creep in the business of everyday life. So that's my concern with the case-by-case basis. Do you worry about this at all?
It's not my job as a lawyer to worry, but as a citizen, as a queer person, of course I worry about it. I can't sometimes sleep at night. And certainly during when the matter was being argued, I spent the longest 2 or 3 weeks of my night spent sleeplessly. But coming back to your point about case-by-case basis, you worry of an idea like a kaushal, right? And a kaushal can come and give a judgment. Now, the point is that if you have a single judgment, because what is the reverse of that? Rather than having a case-by-case incremental growth of the law, you can have everything given by one judgment of 5 judges, which will then be upset by one judgment of 7 judges. I worry about that as well. On the other hand, if you have several judgments of 5 judges, 2 judges, 3 judges, becomes judicial orthodoxy after a point as well.
Okay.
It gets set in the judicial mindset as to how to examine a particular issue. We were talking about Article 14 earlier. That mantra of that in reasonable classification and intelligible differentia has been repeated so often, including by two judge benches, that it has now become part of the orthodoxy, even if that is not the actual test that is being applied. The judge will say that's what I'm applying and go ahead and apply something quite different. So that is what I value in a case by case basis, where a body of jurisprudence is developed, which is then difficult for one judgment to come and overrule 10 earlier judgments of the Supreme Court, right? Yes, it's technically possible for a 5-judge bench in the future to overrule 22 or 3 judge benches, but that's not how courts typically work. The collegiality of the court is such that they tend not to upset a very vast body of past precedent. So I think there is value in that. And the second you said is, of course, uncertainty about a multiplicity of judgments that will come by a bench of smaller judges. Now, given how our courts function, I can assure you that even with larger benches of the Supreme Court, the same uncertainty can well persist, in as much as, I give you the example of, see the jurisprudence around affirmative action in India. Who knows what the law really is?
I don't.
on various aspects. You talk about the issue of basic structure of the Constitution, almost inevitably heard by a bench of 5 judges. Yet, if you try to elicit from the idea of what the basic structure is, there is no clarity, so there is no certainty. So just because there are larger benches and fewer judgments doesn't mean that you are going to have any greater certainty in the law. I had thought that after Indira Gandhi and then Minerva, as explained by Coelho, that the golden triangle of rights, 14, 19, 21, you can't even touch them, right? And yet we have the Judgment on the Right to Education Act, where Article 14 is affected, but they say it's not substantially affected. Now, what does substantially affected mean? So you can chip away at Article 14 on certain asides, but you can't really go to the core of it. So now we have the basic structure of the Constitution and basic structure of Article 14 as well. But in another case, you will not hold that. And then you have the economic EWS judgment, the Lok that judgment.
Yes.
And that interprets basic structure in a completely different way as how Article 14
is. That's not, they just say basic structure. I don't think it's an interpretation of the doctrine with any predictive value in that case.
That goes to my point, which is that you think that somehow getting one large judgment has greater predictive value. I think that's a misplaced hope.
So what you're saying is so much more damning about the judiciary in its entirety. I understand what you mean by it doesn't have implications for this case alone. Now, if I take this line of thought and I think about, okay, now how has the court been deciding these questions? I think there I'm a lot more optimistic. So if we look at, for instance, Shakti Vahini, which is a question of marrying across caste. If we look at Shafin Jahan, which is, of course, the right to choose one's own religion and marry across religion. Or Hadia, which is a more high court question. Or Nalsa, which was on transgender rights. All of them, in all the 3 cases, the question is rooted in individual choice over family or kin or community. And even on the question of faith, it is the individual choice when it comes to faith over the community faith. And this is once again, I think if I take these 3 cases together, specifically Shakti Vahini, Shafin Jahan and Nalsa, the 3 of them together are quite a departure from how we think about personal law in India. And I know they weren't relitigating all personal law, but they were relitigating one aspect from which all personal law follows. So if this is the direction in which the court has been going for, say, the last 10 years, because Nalsa was 2014, then I think that for the LGBTQ community, what we are really going towards is for non-heterosexual couples, the rules are going to be rooted in individual choice, consent and contract. And for heterosexual couples, there's a slightly different default. Right? Now, this may not necessarily be a bad thing, but how do you think about both this evolution and then what this means where we place the LGBTQ community in a slightly different category?
That's, I think, while dealing with issues of the LGBT community, maybe we can shed light on a path forward for the heterosexual community as well. In terms of the personal laws, I'm not a believer of the correctness of the Narusu judgment. To give immunity to a whole swathe of laws, a really outdated principle of what it means to be law within the meaning of Article 13 of the Constitution. It's just not correct. And that's not something the court has consistently done also. When you strike down on provision under the Indian Divorce Act, and so the idea of marriage has changed also from Nauru till now, what it means, from the idea of a sanctified contract which is inviolable to the idea of, again, personal choice. So when we talk of irretrievable breakdown of marriage, we are moving away from the idea of society to the individual making the choice, right? So it's really one path that the society is taking. Simultaneously, the law, both legislatively and judicially, are following that idea. So, of course, judicially gave these three examples of how question of consent and individual decision is central to the idea of marriage, and therefore it should also be central to the other incidents of marriage, therefore not be governed by the personal law. So that's a logical relationship that you are making. And that, I think, is absolutely correct. At the moment we concede that the idea of marriage is based not solely on a religious construct, but is based on the idea of consent of two individuals to come together, and it is then shorn of the religious aspect of it, then it follows that all the other things also should, even for heterosexual couples, follow equally, that it should not any longer be governed by their personal laws alone. And so I do believe that retaining personal laws is not a good idea in the long run. Now, of course, the problem is how to go about it, right? That's belling the cat. What time, who does it, which manner, all of those are contentious political questions. But as far as the law is concerned, and the philosophy of the law and the jurisprudence of it is concerned, and for a moment assume I live in a utopian world where these political questions don't arise, then there is really no reason today, given how marriage is viewed in society, as opposed to 1950, when marriage was viewed in a particular way in society. And Narusu's facts are also very interesting. That was a way to protect certain provisions which were beneficial. That's why the court said, no, we can't have a look at the personal law. So that was I suppose, reverse engineering started with Justice Chagla in Narusu, not just something that happens even now. And Justice Ganjendra Gadkar, of course, who was also a very conservative judge in Narusu.
What are we going to do with this? So one way of thinking about what you're saying is, okay, if we are worried too much about how this is going to upset everything, because personal law, and when it comes to marriage, it literally affects every single person living in the country, unlike a lot of other questions, right? When it comes to property or taxation and so on. So now, one possibility is that there is a kind of individual consent contract choice-based approach for both non-heterosexual couples. And as you said, you will bring heterosexual couples out of the closet. And for both categories, there can be one kind of law. I think the Special Marriage Act was going in that direction, but didn't go all the way. There's a kind of personal law which is completely divorced, forgive the pun, from any kind of religious custom. So that exists simultaneously with all your personal laws. The alternative is what has been talked about many times, a kind of uniform civil code. So these, to me, seem to be the two options on the table. And I understand what you mean by short run versus long run, and you know how this is done and which parliament does it. Are you at all worried that when we are advocating for individual choice and moving towards a very systematic, clean personal law that is divorced from faith and custom, the sort of agenda of the LGBTQ community is going to be captured in some way to pass a uniform civil code and affect other parts of plurality in our system and so on?
I'd welcome the mainstream to capture the LGBTQ agenda, in quotes. A, there is no real agenda. B, the mainstream is running away as far as possibly can. And by the mainstream, the government, not the person on the street for whom a lot of these academic questions may not come to the mind. So if the LGBT point of view is used to bring reform in the law for heterosexuals, I wouldn't call it capturing the agenda. I would say it's taking a good idea and running with it. And that's absolutely okay for me. There are many other battles that the LGBTQ community has to fight. And if something that is useful for them is taken over and someone else fights that battle for them, say a feminist coalition, for instance, fights for certain rights, so be it. I would see it as an allyship rather than any hijacking. Of course, my worry in a uniform civil code is that you would have some kind of a Doma argument. So then a specific exclusion of non-heterosexual couples from the idea of marriage, an explicit prohibition. But that really doesn't worry me too much because that's exactly what the law today is as per the arguments
Is.
of the union. So we're already excluded. So then once it specifically forms part of a provision, supposing it does come, then it is very easy to challenge a section which is explicit and says two non-heterosexual people cannot get married. There, the Article 15 violation is writ large on the statute book, so striking it down is easy. So I think sometimes covert discrimination also is useful. But I'm not worried about the agenda at all being hijacked. I really believe a time has come where marriage has evolved from purely a religious concept. And of course, it'll never cease to be. Some element of it is religious and it'll never stop. That will never stop, right? But we must distinguish the idea of marriage from all its other incidents as well, including divorce, maintenance, alimony. Those are not necessarily typically clear in religion. And there you can make a uniform civil code without doing structural damage to the idea of marriage as a somewhat a religious concept as well. Because really, I don't think we can completely do away with the idea of religion in marriage. But I think the better way to do is you choose your ceremony, but the other incidents will then follow the uniform civil code. And that will be very useful.
No, I agree. So my personal belief is either government should not involve itself in personal law at all, and we leave it entirely to custom and contract, or if it is involved, then all people must be treated equally, right? So since we are very far from the realm of the government must not involve itself, so if I were to take the current existing structure in India, then I'm obviously leaning towards the latter, right? Which is a uniform civil code, not just across all faiths, but also for heterosexual and non-heterosexual couples. So that's where I'm headed. I understand none of this is clean. So now I had a question about the ceremony part of it, right? Because I thought that's one of the first things that's going to get challenged. And this is going to be a very 1950s temple entry ban kind of situation. So let's say that the Special Marriage Act and the Foreign Marriage Act are actually read up. And we already know that a lot of non-heterosexual couples do have ceremonies where their family members attend and so on. And the way India's navigated it is, given that it doesn't have legal validity at the moment, you just find a priest who's progressive or family member who's progressive who can conduct the ceremony. Now, let's say you get the Special Marriage Act sanction and it comes under 15, right? And 15 is not just equal protection, it is also non-discrimination. Now, if this couple, like most heterosexual couples in India who do get married under Special Marriage Act or get it registered, also have some kind of, if not purely religious, some traditional ceremony, which is faith-based, that is going to be explicitly unavailable to LGBTQ couples. So do you see that as the next frontier, that you're going to have LGBTQ couples now say, hey, we have to be allowed entry in temples and we have to be allowed entry in mosques, and a priest can't discriminate because Special Marriage Act allows us to do this. And that sort of starts conflicting with 25 and freedom of religion. Because I see these are the problems in our future. If we go in the progressive direction without an overall solution, this is the next step, right?
But this next step is happening all across the world. I think the clash between a right to against discrimination and the right to have freedom of religion is inevitable. In the Indian context, I think it will be slightly less so because there is no, for the substantial majority of the country, which are Hindus, there is no centralized church. So you will always be able to find some priest or the other who will be willing to perform the marriage. Yeah? I think that is a problem that is maybe more for the Muslim community or for the Christian community, whether you have access to church or not. And then, of course, that is again a battle that will be decided on a case-to-case basis as and when the dispute arises. It cannot be done in a one-off, quasi-legislative manner to decide all these issues.
Yeah.
But yes, there will be a clash, I can quite see, between religion and personal laws on the one side and an individual's choice on the other. But we've seen those clashes even today in the love jihad matters, right? A Hindu woman gets married to a Muslim man. There are conflagrations. Society deals with it. And then you have, of course, Shafi Jahan. You have the judgment that the courts step in. Even when the courts do step in, it's not as if a problem goes away and there is a problem of still outside influences, social influences, trying to stop these marriages in a non-legal manner. So even if the law
Yeah.
can be sorted out, the problems will persist as they do today between heterosexual couples. So that's a larger cultural, societal debate that we really need to have. I don't think that's a problem that the queer community alone is going to face. And secondly, the queer community, it's not as though millions and millions of people are today dying to get married in any case. This is not something that's,
Yeah.
yeah, it's not, it's far less widespread. I would love for the whole country to be queer. But the fact of the matter is, it's 5-10%. Initially, I think, as when so many people in the closet as well, it's not as though there will be a floodgates of queer marriages. It's going to be relatively an unusual phenomena, which will then increase as time goes and society accepts. And as society accepts, there will be changes in both how people react to the idea of queer marriages. And maybe at that point of time, society will be more progressive and therefore start accepting these marriages. And that clash really between religion and individual choice may not happen. On the other hand, I don't know how it develops. Maybe there will be a backlash. And as marriages become more common, then there will be more of a clash. In my perception and understanding of how I view India is that I think the former, that I think there will be greater acceptance of it. We are not innately and inherently a nation that likes to stop other people from living their lives by and large. There will be vigilantes
Yeah.
and activists on the fringes who will act up, right? But that's not the mainstream view. And if two queer Hindus are getting married, I don't think, at least, that the larger Hindu community is going to be terribly upset about it. I really
Yeah.
don't think that's the case.
It's typically a family barrier. If the family is accepting, then immediately all the other benefits of they'll find a priest and they'll find the community to attend a traditional ceremony, all those things follow. And if the family is not accepting, then even for heterosexual couples, it's really hard. So that's, I think, usually where it comes to bear. But that's a question of fact, much less law. If you permit me to ask you how some of this has impacted you personally in two aspects. When I was talking about how marriage is really important for the everyday business of life, in your case, there are two questions when it comes to discrimination. Your name is currently under consideration for elevation to the Delhi High Court. I believe it has been so for many years now. And you would be the first openly gay member of the bench if you were appointed. Now, of course, the collegium is a complete black box, so none of us are privy to the minutes and what has been discussed. But from what I've read and understand, the major question for the government is that they're actually not able to completely wrap their head around your peculiar situation of having a long-term partner who is a foreign national. And this problem gets solved if you were in fact married, because we've had people in very high office, including the current cabinet minister for external affairs is married to someone who was foreign born. And that has not caused a security concern or interest of the sovereignty of India and so on. But in your case, because it's not marriage and it can't be marriage because that's not permitted. So you're either in a situation where you have to break the law and go abroad and do certain things and try to sneak this into some kind of marriage umbrella, or you are excluded because the government says that they can't vet your quote unquote family. So can you, if you're comfortable, walk us through how this case resolves that question? I know it can't resolve homophobia, but how this resolves the logistics of everyday life, which are actually very discriminatory for everything, including an elevation to the bench.
Just talking of my elevation, for instance, I think this case will resolve something and nothing simultaneously. Something was in as much as, well, yes, once I get married, then there is really no reason to discriminate between a heterosexual and non-heterosexual person when the person assumes constitutional office. You mentioned the current cabinet minister, but I'll only remind you that we've had one prime minister who had a foreign spouse. We've had a president who has had a foreign spouse as well. It shows you that the problem then is not the idea of a foreign spouse. It is the idea of a non-heterosexual person. So I think a lot of the terminology that has been used is really trying to get at that. So that's why this case will solve everything and yet solve nothing. So technically, yes, one will be married, and therefore one can make the argument that there is no difference now between me and someone else. And again, I'm just talking purely technically from a legal perspective, not my own. But it will solve nothing as well, because as long as the government believes that having some foreigner is peculiarly disabling for a judge, then that problem remains. then that has nothing to do with marriage. For instance, I give you an example. Supposing if one were to be single, one gets appointed or elevated to the bench and then finds a foreign partner, right? Would then that person be automatically impeached or disqualified?
Yes.
How would this work?
Yes.
So I think some of these points have been dealt with by the collegium resolution, saying that given the fact that judge is not privy to confidential information, because the whole business of judging happens in an open public platform.
Sealed envelopes notwithstanding, but yes.
Moving away from that sealed envelope jurisprudence as well, thankfully, because you're expecting one side to play with their hands tied behind their back. So obviously that's going. And if that be the case, then really the technical objection of failure to get married would disappear with this case. But that's not the real objection. And if the real objection is non-heterosexual foreign spouse, then that objection will remain regardless of the status of the marital status of the individual concerned. Now, the day-to-day business of living, now, of course, that for us will become considerably easier. My partner is not an Indian national, then we'll be able to stay in India, get OCI card, hopefully then get Indian citizenship at some point. We don't have any Swiss nationals who will wish to become Indian citizens, but he is one. Joint bank account but technically any two people can open a bank account together. I can open with someone unconcerned. I can, including with my partner, open a bank account. But supposing I put money in that bank account and he spends it for our day-to-day expenses, then it's income in his hand. And he will have to pay tax on the money that we have in the joint bank account. So that is another problem. I can't get insurance on for him, etc. So these are multiple daily problems of those 160 laws. Now that's something that comes back to what the solicitor argued in court and said that marriage is an extremely valuable social institution, and that 160 laws will have to be amended, and that's how fundamental it is to the life of an individual that 160 laws relate and concern themselves with that aspect of a person's being. And so, if some institution is so important that you need 160 laws, no less, to deal with that particular aspect of an individual, then to exclude the non-heterosexual community from it, and thereby disabling them from the privileges and powers that come with those 160 laws, is in itself obvious as to how the life will improve for an LGBT couple, is then you will have access to those 160 laws. That's precisely what the argument is. I think it's a circular argument on the part of the government and a self-defeating.
Yeah, I was actually smiling when I heard that. Now we have the video transcription of what happens in court. And I was smiling and I was thinking, does Tushar Mehta realize that he's just strengthened the case under 15(1) for what is going on and how this is truly discriminatory in every aspect of life by invoking the operationality of the 160 laws. But you're absolutely right. India is a marriage society, right? Everything stems from marriage, all privileges, whether even something as simple as the ability to hold someone's hand in public and everything else that follows. India is just truly a very marriage-based, marriage-driven society in terms of public acceptance. Right from the cop stopping you to getting insurance, to getting pension, if you die interstate, what happens to children, are you included in the Hindu undivided family business or not? Every single thing starts flowing out of this. So it becomes it's extraordinary how discriminatory it is as it stands.
Absolutely. Adoption, something that we can speak of. Surrogacy. Because you see, now what is happening is that a concept of exclusion of non-heterosexual regime is happening. Non-heterosexual couples are being ousted from access to all kinds of other institutions. So, adoption, surrogacy, IVF, assisted reproduction. Now, on all these matters, a heterosexual married couple is being elevated to some kind of a special status, with the consequence that everyone else who needs this more than a regular heterosexual married couple is being ousted from this.
Yeah.
It's typically a non-heterosexual couple that will require adoption. And yet you're ousting the group that most needs it.
Yeah.
So there are multiple problems, and it's getting worse in terms of the legal regime. So maybe once the judgment comes, it'll have an impact on not just personal laws in marriage, but on the creeping form of discrimination that is entering into the personal choices of people in areas other than just marriage. Why can't a single person get a surrogate child? But the law today says you can't. And that's nothing to do with
Yeah.
marriage, nothing to do with sexuality, but it is everything to do with personal choice. So there is a kind of an attack on a personal choice through the elevation of this heteronormative, almost patriarchal idea of
Yes.
what, because heteronormativity in India is patriarchy. We can't separate the two, really. Technically, one can, but in practice, it is that. So we are elevating now patriarchy to the status of law and dogma. And that is why I think this judgment, I hope, will be timely to stop that happening.
When I was reading your book, this is Sex and the Supreme Court. It's a wonderful collection of essays that you've edited, and you've written one yourself. The glaring sort of theme that emerges from the anthology is that we are very Fabian in our approach to personal law, not just economic laws. And what I mean by Fabian is we are both gradualist and paternalistic, right? These are the two characteristics of Fabianism. So we want things to happen through a somewhat legal, formalistic or democratic process. So it shouldn't just happen willy-nilly. But at the same time, it will be done in small marginal steps, and it will be done not keeping individual choice in mind, but a certain kind of paternalism. And the problem with that is the paternalism keeps getting outdated, right? So we find ourselves in situations where, women who are in heterosexual couples and upper caste and privileged are actually less vulnerable than men who are from marginalized communities or men who are non-heterosexual. So we are now entering these questions. Now we don't know who we are supposed to be paternalistic towards. Do we need some kind of radical solution to how we just think about laws? This old Fabian way of doing things just has to change, and it is the queer community and the transgender community that's going to get us there, because they are the only ones who can show us the mirror and see how glaringly like paternalistic and bad this has been so far. At least that's what I get out of the book, whether it's Me Too, whether it is Johar, everything.
No, that's to some extent is a kernel of truth. Now, I just break it down in my own head, is to say that there is a problem, which is that the law is not changing fast enough to keep pace with the problems not only of today, but potentially tomorrow. But there is a certain incrementalism, which is inherent in the process of judicial lawmaking. Right? So you don't want a judge to just suddenly discover a new article in the Constitution and say, hey, no one had seen this before, but I found it. And then give a series of judgments which are completely divorced from the text of the Constitution, because that kind of judicial indiscipline lends itself to a judicial dictatorship, which is, there is no really room for that in our democracy, but also, as I said, a backlash and inevitable overruling. Right? So the judicial process is by definition and by design an incrementalist one. So that will happen. However, the queer community can do, and the trans community in particular in that, I think, given the level of deprivation, is that the resistance that they offer should change a mindset in society, but then hopefully will get reflected in the lawmaking and the legislature. Truly revolutionary change can happen only by a legislative process. One big judicial break I want to see, and that will be consistent with the Constitution, is the overruling of Narusu. So the infiltration of the fundamental rights chapter into the personal laws of communities is something that's imperative, right? So that is one big thing that needs to happen. But even when it does happen, I think given how conservative the courts are and how the decision-making process is, that will still be a step-by-step matter. It's only when someone brings a list to court is that court going to decide. And that is not, however, the domain of Parliament or indeed the state legislature, because after all, personal laws are matters in the concurrent list. Even states can change it. Most have not chosen to do so, say for Goa, the state where I'm currently sitting in and enjoying the lovely monsoon.
Oh, how lovely.
So coming back to that, I think the queer community and the trans community can make the problem so obvious of what the problem with personal law is. For instance, the discussions that were happening in the marriage equality case is when you tried to put in a square peg in a round hole, it just wasn't working. It showed that it's not the problem with the peg, it's the problem with the hole also. So that's when you start questioning that laws need to change, and maybe the LGBTQ agenda will be hijacked, hopefully, and used for bringing reform through the medium of legislation into effect. I think that is what I'm hoping for. But that paternalism that happens, that is a paternalism that That's inherent in all aspects of decision making, both legislative and judicial. And that for that you need to fight patriarchy in some other ways through education, not necessarily through the medium of the very thing
Yeah.
that is paternalistic, i.e., law. You don't think, I think that's going to be a failed effort to try to use law to bring about change there. It's not going to work. I think the problem is far too deep rooted and cultural to be changed through the medium of the law. That's not the correct social tool.
I have a lot more faith in the LGBTQ community achieving this because, in one sense, yes, it upsets the way we think about custom and faith, and more so for some faiths relative to others. But in most cases, they are not subtracting from anyone else's rights while demanding their own. So I think that is a very important social acceptance tool where basically I think that's the reason 377 also found so much social acceptance and celebration, which is this is not in any way affecting heterosexual couples. Like non-heterosexual couples' behavior does not change anything for us, and bare minimum in a civilized society is that they shouldn't be punished for it. So though we are very conservative society, it didn't seem to matter in that instance, and I'm hoping it's the same for marriage, right? It doesn't prevent really heterosexual couples from doing whatever they want, marry or choose not to marry. This doesn't subtract from them in any particular way.
That's true. If that were the only thing, that it is not going to affect a heterosexual couple, then how will change come about in heterosexual society? To say that a non-heterosexual marriage will be completely independent is not going to make any difference then. It will, however, I think make a difference, because once you have to create a new architecture to deal with a wholly new problem, right?
Yes.
We've not had to have legislation in the past to deal with the idea of the queer community, and then a wholesale relook at the idea and the concept of marriage for a particular group, i.e. the non-heterosexual group, offers an opportunity for Parliament to step in and apply its mind and use that opportunity and occasion to reimagine what a heterosexual relationship can also look like.
No, I completely agree with you. I was talking more in terms of social acceptance. I don't see like big protests and huge backlash. Of course, there are small interest groups who are always going to make some noise. But broadly, like the people of India, I don't think are going to try and fight and deny other people very essential rights and access to very essential services. That doesn't seem to be what the question is right now. I know there will be religious boards and there will be a class of clergy across all religions who suddenly come out of the weeds to discuss this. But you're absolutely right. I think the reimagination is the big question.
I think I share your hope and optimism that will happen because I just remember 2018 and Navtej Johar, and you have a very literate audience. But for a vast majority of the people on the street who I've spoken to, they seem to believe that after Navtej, you have the right to get married. The people are often surprised when you talk about that we are fighting marriage equality case, because they think that already exists. And they were okay with that. The only people who have an objection with the idea of marriage equality are the urban elites.
And the government bureaucrats who have to give you the stamped paper.
Point is that the urban elite argument that is employed against marriage equality is something I'll turn around and say that the only people who have objection to marriage equality are a certain class of urban elites. A vast swathes of India is absolutely okay with it. They think we have it already. And for any Indian parent, more than anything else, their desire is that child should get married. Mere bacche ki shaadi ho jaye. Right? That is the be all and end all, along with getting a government job maybe, or getting a good job somewhere.
And children.
Correct. So now if adoption is permitted, marriage equality is permitted, it'll just revolutionize how people see queer people and how families see, because there will then be an opportunity for a belief that their child will have a full life. Right? It's not as though one part of a parent telling their child that get a job and get married is because who will have children for me and who will take care of me in my old age and take care of ancestors, how will you get purified. Another thing is worry for the child. I think I also see that is that their parents are worried that what will happen to my kid if they don't get married, don't have a family. And if they can see that no, there is a possibility of that, I think families will be more accepting. And the moment a family accepts a child of their own, society kind of follows. I've found that personally in my case, and I've seen that in many other cases, is that the moment your immediate family and even your extended family accepts you and calls you their own, and there is really no room for anyone else, and people don't generally comment on it. I think that's how Indian society is.
And the one very interesting thing you pointed out right now is In India, most marriages are not registered, right? We don't have that requirement. So it's presumed to be a valid marriage, right? That's the presumption, unlike many other countries. So in India, I feel like there's also this conflation of the law, right? That if it's not explicitly outlawed, it's not like we went to an office and got our marriage registered. We just got married with acceptance of the family. So presumably that's true for non-heterosexual couples also. So I understand. I don't think they're being simplistic. I totally understand where that is coming from. It's because that has been the reality of their life. It's only the urban elite who have very high level of legibility when it comes to the state and passports and OCI cards and all a fair amount of wealth, which then needs to be resolved in a particular way. But that's simply not true for most people in India, both from a property point of view and from a registration of marriage point of view. So it's quite interesting. That's where this is coming from for me. Even that is a very interesting divide and makes me quite optimistic for the prospects of the queer community.
That's absolutely right. I mentioned this earlier example about the Tamil Nadu amendment. And it's common across India for couples to just go and not even perform the legally recognized Saptapadi. Under the Hindu Marriage Act, you have to go to the sacred fire, make those 7 steps in the presence of the sacred fire. People may not have done that. So technically they may not even be married under the Hindu Marriage Act. But if society accepts you as married, then that's that.
Good enough.
What else is marriage if not primarily a social / religious institution? And if it's accepted by society and it is capable of functioning beyond religion in a secular space, then marriage already exists. There are so many examples of people in the last 50, 100 years who go to temples, same-sex couples and get married. It's very common. And it's accepted. They're not lynched. It's more likely to get lynched if you have of the same opposite
different
religion.
Caste.
Or the endogamous, the same gotra, or if you are of a different religion, you are more likely to be beaten up then as a heterosexual couple.
So I want to now switch gears to your other book, and this is 15 Financial Judgments which have this big impact on the Indian economy. First of all, I was thrilled to read it as an economist. I'm a little exhausted by the same old, like one more paper and book on Keshwanand or something like that. There's a whole new jurisprudence that we need to look at, especially in post-liberalization India. So I'll start with the first case that you have in the book, which is Kameshwar Singh and the question of property. The way Kameshwar Singh was set up, oddly enough, it wasn't a property challenge as much as it was an Article 14 challenge. So I feel like we are back to the same theme as your other book and marriage equality, and different classes of landlords and zamindars cannot be treated differently. You've talked about the consequence of that, both in terms of creation of the 9th schedule and in terms of all the 13, 14 different amendments to Article 31 to 31 ABC, like all of that bouquet put together. And you've talked about what we get is more and more state infringement into everything. And now it's not about land reform anymore. Now this is about how much foreign exchange you can have in your pocket and whether you can be thrown into jail for it. At one point in the 9th schedule, all the emergency laws were included. They were, of course, removed. There were only 3 laws which were ever removed from that provision. And these were the censorship laws, the Representation of People Election Act, all the things Indira Gandhi tossed in. So you worked that out quite clearly. But to me, in that case and the many other cases that you discuss in that book, it seems like the courts don't have a very clear understanding of what is the role of the state in an economy. So that's part one. And following from that is they don't have a good understanding of what is the role of the state in a transition economy. So what is happening in India is literally on a case-by-case basis, depending on the judge, depending on the lawyer, depending on how privileged the petitioners or the respondents are, you're getting a particular kind of jurisprudence. But in standard property rights and expropriation cases, what we ask, is there a public interest or public use case which completely relies on our understanding of what is the role of the state, right? If the role of the state is night watchman and it's only to provide roads and things like that, then Kameshwar Singh is out. If the role of the state is to bring about more egalitarian society and do social reform, then Kameshwar Singh could potentially be in, notwithstanding the Article 14 problem. But a lot of the other property cases would not be in if it's just about social reform. But we have expropriation cases in India where the question is, okay, now we've expropriated for the housing society of HMT. HMT is a government-owned company. So where is the line drawn for what is the role of the state in a socialist economy and then a transition economy and a post-liberalization economy? To me, that seems to be what comes out of the 15 judgments. So is that the way you think about this question, that we just simply have no clue what we want to do with the state?
Provisions in the Constitution which dealt with property rights had provided an anchor, I think, to a potentially non-socialist economic ideology. It could have done that. That's why they had been inserted. And the moment that anchor was removed by the First Amendment, there was this kind of a ideological drift, because there's really nothing in the Constitution at that point of time then to explain as to what is it that the constitutional philosophy qua property is. Right? So every time you have a recognition of the right to property, an amendment happens and that particular aspect of the right to property is removed. So it seems that the Constitution becomes less one that values property and elevates the role of the state increasingly, right? So that happens through a process of constitutional amendments, and that filters down to the judge's understanding of how the Constitution is. Because simultaneously, I can't say that the judges are absolutely deciding whatever they want to decide and yet say that they should not be bound to the Constitution. Of course, they should be. So it's inevitable that when you remove the property articles and you remove and you amend the right to business 19(1)(g) and take away and permit government monopolies, which also happened by the amendments to the Constitution, you are giving a certain kind of a statement as to the kind of economy you envisage, which is one that does not value private property. So the moment you send that message out, and then you have directive principles in your Constitution, Article 39, which says that the property must be used for the common good, it then lends itself to the enhancement of the role of the state in a paternalistic sense, as we were talking about earlier, of course, in a different context. And the court sees itself as a participant in the promise of that constitutional vision of egalitarianism and equality, right? As an enabler somehow, because now the constitutional view of the courts has shifted from it being something that protects private property to the removal of inequality. From the sense of protection of the individual and fundamental rights inhering in the individual, that somehow in the fundamental rights chapter, qua property is completely gone, and from rather than the individual being at the center of the constitutional values and part 3, it's now suddenly the state which trumps it. And that filters in judicial thinking, including even now, you talked about the right to property and acquisition, HMT, even after the enactment of the 2014, the
LAR, land acquisition, something, yeah.
That long act that you will no doubt put in the link to. There was a judgment of Pune Municipal Corporation which interpreted the act in a particular manner, saying that mere deposit of money in the account would not be enough. And second, you had that or being read as and. Then you get a constitution judgment, and that overrules the Pune Municipal judgment. And that judgment also has a certain socialistic mindset. And not quite socialistic, because really, I think it is more case of valuing the state over the individual. Because land is often acquired not for
private companies, actually.
It's taken for private companies, and that's done through the agency of the state. So it is believed that the state is a big brother, and you have your private property only at the discretion of the state. And that has a certain view on the transactional nature between a citizen and the state. And that's another problem I have felt with the First Amendment and the series of amendments thereafter, is our disdain for the idea of private rights. And not just property rights, but even free speech. We are not a society today that values our fundamental rights. And every time you mention fundamental rights, someone will stand up and say fundamental duties, directive principles, not realizing that's not the Constitution.
They're not the same thing. They're actually in conflict.
And when you read the preamble, idea is that you will have the unity and integrity of the country through the development of the fraternal society by protection of justice, liberty, and freedom of the individual. I'm just saying the preamble in the reverse. So that's how it is. The idea that the individual rights will ensure that the state is secured. But this has been placed over on its head in the popular imagination, in the legal imagination, and increasingly in the judicial imagination as well. That rights, fundamental rights, are almost
They're endowed by the state. They're not inherent in the individual. That's basically it.
And even though the law is to the contrary, the judgments say
Yeah.
that is not the position of fundamental rights and that they are inherent in people and it's not as though state has granted them. But when it comes to actual decision making and given
That's how they
yeah,
use.
that's how it is
Yeah.
viewed. Is that here, take something or no, you will not get something.
So here I want to push back. Actually, it's not really a pushback, but maybe an addition. So I completely agree with you that the imagination has been one where the rights of the individual have not gotten the sanctity that the original constitution had imagined. And this is most clear in property and all other economic laws, including freedom of trade and profession and how we've outlawed certain professions and allowed monopolies and so on and so forth. So that's one part of it. But to go back to the judges, I feel like the other jurisprudence that developed in India is one of legislative deference and executive deference. If we look at all the property, especially the constitution bench cases, it comes down to oftentimes amending the constitution. But when it comes to was the state allowed to take property in this instance, and the question of was it right to do so and did it satisfy public purpose or public interest, the judges have always read that since 1950 as public purpose and public interest is whatever the legislature says it is. So what we get is statement of objects and reasons which will explicitly say this is the public purpose. And then the judges will say, okay, that's fair. That's public purpose. Now we're going to get into the nitty-gritties, which is why our jurisprudence developed around equal protection or the lack thereof, or around compensation or the lack thereof. And the courts have never really examined what is the role of the state and therefore what is the limit beyond which the state cannot exceed. And this obviously has implications both for economic and personal law. It permeates everything. So I would just add that to what you said, because that's where I think it has come to bear when it comes very specifically to the question of property.
No, I think that's correct. And that relates back to what I said, is that there is no ideological or constitutional mooring for this. When you say public purpose, obviously public purpose is who is the best judge of the public purpose? Is the legislature or the executive? It's not going to be the court. And public purpose can be trumped by a fundamental right always. But if that fundamental right ceases to exist, then obviously public purpose will take over. So it's not surprising that this has happened. Public purpose is an exception to the Article 19 rights in the 1902 to 1906. But first you have a justification or a violation of a right, and then you can rely on public interest, not public purpose, but public interest.
Public interest, yeah.
So but in the case of property rights, there is no such equivalent. So there, public interest mutates into a public purpose kind of a thing. So you're right,
yes,
to say about public purpose. So public interest becomes public purpose, and public purpose is then just a completely unruly horse, and the government can fit anything on it. And there is no real way for the court, jurisprudentially or constitutionally, to say that this is not a valid public purpose, or the doctrine of eminent domain that is evolved in the US has not really quite applied itself to been applied in India either. And that, as I said, is because of the First Amendment and our mindset and our current state of the Constitution. We need the right to property.
Is it also because our courts, just the way they've evolved, especially post-emergency, have been largely about expanding the basket of positive rights and entitlements, and they haven't been so vigilant about guarding negative rights? That's another trend I see, and it bothers me a lot, but it's part of getting along and chugging along in this crazy pluralistic society. So it's a messy one. You don't want to touch it. You don't want to take away positive rights and entitlements because that's the only way to read the Constitution. But on the other hand, that's the bias that I inherently see in the courts. Negative rights are almost, they don't really matter because we're not really about taming the state or being an anti-majoritarian court. That's simply not us culturally.
I think the ideas of the benevolent elder, right? We grew up in Indian families where the senior person is always right. We always listen to what they say and they can do no wrong. And that is something that has entered probably the judicial mindset as well. The idea of the benevolent state. And rather than the state being the aggressor, it is always the protector. Now, if the state is a protector, then you don't need a negative right because they're not unlikely to do something. It goes back to, you said post-emergency, but see the judgment of the emergency in ADM Jabalpur. When the judge says, I have a diamond-sharp hope that rights will never be violated. An idea at a time when fundamental rights themselves are suspended, the judges still find it within their heart to say or able to say that they don't think that the ever the state will take a decision which is contrary to fundamental rights. When there is evidence upon evidence and habeas corpus cases are coming to the court, they look away from that because the idea is of the benevolent state. And the idea of the constitution also delineating powers and responsibilities between different organs of the state, including also not just between the organs of the state, but between the individual and the citizen. And what is the role of the courts in deciding a dispute between the individual and the citizen? A constitution doesn't simply decide checks and balances of powers between the three organs of the state. It also reimagines what it means to be an individual in that state. And a very delicate balance was given in our constitution in part 3, when fundamental rights are seen as the most important things anywhere in the constitution. Laws can be struck down if they violate fundamental rights. One person's right is enough to strike a whole law down enacted by a unanimous parliament. So that was the original conception. But with the passage of time and the amendments to the constitution, this system has been reimagined. And that is why positive rights have come into play, because state is now enabling. And not just the state, unfortunately, increasingly, the court sees itself as in loco parentis and says that we can now step in and now we will protect your fundamental rights in a positive way that the legislature doesn't. And who do you go to when the court oversteps the boundary? When the legislature oversteps the boundaries, you can go to court and say they've overstepped their boundaries. What do you do when the court does that? There is absolutely no recourse. There's a big problem in imagining all rights as positivistic or positive, not positivistic they are, positive in a positive sense. But who is the arbiter about what is the extent of that positive is a big problem, and increasingly one that the courts are wading into without considering the consequences of what they're doing.
Anuj Bhuvania has written about how post-emergency, the court basically refashioned itself as a populist institution as opposed to a counter-majoritarian institution. And some of it has to do with how they suffered during the emergency and they didn't have the public support and they had to refashion. Part of being populist is you need to hand out welfare entitlements and you need to expand positive rights. So that's just part of the populist manual. But the consequence of that is then you can't, in good conscience and with good consistency, also be a check upon majoritarian forces and the legislature and the executive. And so to me, that's another trend. So this to me comes to bear not just when it comes to demonetization or Aadhaar or any of the latest cases also all the cases which are in the book, but also when it comes to marriage equality and Johar and Kaushal, right? So when I was watching the video transcription of what happened in court, it was so clear that the questions that the judges were asking all of you was about how do we make this operational? How do we balance the interest of this community? How do we balance the interest of that community? So if you're a populist court, that's your concern. But if you're an anti-majoritarian court, your concern is this 14, is this 15, is this 19, is this 21? So this is what I see happening, and it somehow permeated all financial law, but also all personal law. Am I being too uncharitable, or is this really how the court functions?
You're not being uncharitable. That is the reality of adjudication. Maybe I don't blame the judges because they have to carry other burdens that you may not be aware of in the court. But the fact of the matter is, if you go strictly by what the law and the constitution demands of them, these questions are irrelevant. And they will play lip service to that idea as well, that we are not concerned about what it is. We just, however, asking. But you don't ask a question just in the air. Presumably, it's weighing on you somewhere. So you will find judgments even when they come that ultimately this is all about fundamental rights. And I have no doubt when it comes to the marriage equality judgment, you will see the same thing. They'll not talk about what the majority thinks. But if it's playing on their mind, it is playing on their mind. And sometimes they make it explicit in the judgment. More often than not, they do not. They do often make it explicit in arguments in court, but not always. But it is in their mind, of course. And it is a function of them being not only populist, but also seeing their role as I said, the benefactors. Right? It is no longer just a system of checks and balances where the court decides disputes between different organs of the state and between the individual and the state, but also sees itself as a participant in the entire decision-making logistical solutions of social problems. And the moment you become a participant in that, then obviously concerns will inevitably, like a spider's web, the Fuller's article, they will then they come in, and then they have to be dealt with. And the moment marriage equality as an Article 21 as opposed to an Article 15/14 problem, then maybe some of those concerns are valid of the court. But if it is framed the debate in a negative sense, as you said, in terms of 14 and 15, then these questions are not really relevant. We now have what is called an integrated proportionality test in some judgments. That when there's a violation of 14, 19, 21, they're all put in a blender and
Yes.
outcome.
And then we wave our hands a little bit and then something comes out.
And maybe that's at least judges being honest. That is what they're doing. So maybe that's okay. I may not love that as a strict student of constitutional law, but at least that has a merit of honesty. And rather than applying the traditional Article 14 test and coming out with something completely different and you doing what you want to, you are at least bringing to the forefront of what you're really thinking. So that may not be a bad thing. But of course, I don't think that's the role of the court. And I think the court has overstepped its boundaries and therefore has not been true to the needs of the people and the needs and demands of the Constitution in terms of its role, and also has rendered itself vulnerable to attack both by the public at large and government. Now, if you're going to take decisions which are beyond your area of expertise and jurisdiction, and then obviously you're going to face scrutiny by a jealous legislature saying that this is our, it's not envy, I think it's jealousy.
I think that's fair, but I think it's gone beyond just taking over the domain of the legislature and oftentimes the executive, or actually the executive almost on a daily basis, the legislature in cases like Vishakha and other more explicit instances. But I think how much of the problem do you think comes from the fact that, one, it has become a self-appointing institution, and two, in more recent cases, the rules of transparency are for other institutions and not for itself, right? Whether it is the black box of collegium or whether it is sealed envelopes and things like that. Vishakha applies to the entire country, but the only institution Vishakha does not apply to is the Supreme Court of India and the Chief Justice of India. So how much of this loss of legitimacy is entering the domain of other branches of government versus actually being quite inconsistent and very self-serving as a group? And that's what's made it even more vulnerable. To me, the latter seems to be more heavy because the former has been going on for a long time.
I think the legitimacy that the court enjoys is a moral legitimacy that comes from doing the right things, the correct things. And the court has sometimes been remiss in that. So, for instance, the case of Vishakha not applying to the Supreme Court is just, to me, frankly, inexplicable. It is just absolutely inexplicable. There is a woman who is complaining of sexual harassment. Good, bad, indifferent, that needs to be investigated thoroughly in a manner which is impartial, unbiased, and in the same way as it is by any other institution. The focus is not who has committed the wrong, it is a question of who the wrong has been committed against.
Yes, and the rules that they themselves wrote.
Absolutely. They themselves wrote. It's really also, this reminds me of Justice Singhvi's judgment on the red lights in the car. He said that you cannot use red lights on cars as if you are VIPs, but for official purposes, you are allowed to use those red lights, and judges need it for official purposes. I never quite understood why the judge needs the red light any more or any less than another important functionary of the state, but that is often the judicial thinking. On the collegium, of course, I have a different view, and I don't think it's any more a black box than whatever else it replaced. The problem of the collegium is not lack of transparency. It's the system before the collegium was even less transparent than this. And a lot of the judgments, which are populist, as you mentioned, were given by judges who were appointed in the pre-collegium system. Justice Krishna Iyer, Justice Bhagwati. These are judges who have been appointed in the earlier system and have been responsible for giving us the jurisprudence we have today. ADM Jabalpur judges were not collegium appointees. I don't think the problem then is a collegium. I think the court needs to understand that the legitimacy comes from popular acceptance. And popular acceptance is not the same as acceptance by the state. The state and its people are two different creatures. And that is something, again, as I said, we need a reimagination of the interlinkages and the relationship between the individual and the state. The role of the court in protecting the individual. I think if the court was to come down and protect the smallest person against government and was to strike down government action more often, it would gain more legitimacy in the eyes of the people and not less.
I agree with that. The other theme that I see coming out of the Financial Judgments book is that, and this is again in a post-socialism setting, a lot of the cases are, other than Kameshwar Singh and R.C. Cooper and so on, many of the cases that you discuss are post-1991. You talk about the importance of rule of law and certainty and how the court needs to provide that. And that is an essential aspect of conducting business. Now, if I were to take even more first principles approach, then the most important institutions supporting the market are ones that support exchange and therefore contract and adjudication of contract, right? How much of the problems are coming from the court's jurisprudence in a failure to understand this versus how much of it is just they're not doing their job? We're extremely understaffed. We have massive judicial pendency. The rich people go immediately into arbitration and the poor people wait endlessly or have contracts under the shadow of the law. So this has become like we've created the dual system, the formal arbitration system or bypassing through tribunal straight to the Supreme Court or High Court for the privileged. And everyone else is in the informal sector, which is, of course, in the shadow of the law. So this is the dual system we've created. And that is the largest macroeconomic consequence of what we're talking about. So to me, that's the other thing that comes out of everything that you're saying post-liberalization. Pre-liberalization, the state is overwhelming. So the cases are really about the state. Right? Now we're in a completely different realm. So to me, that seems to be the problem. How do you view this? I know that I'm not asking a question about individual judgments, but this is a question more about the institutions and how we think about the role of the institution.
See, I think the problem, of course, is less about the actual final decisions that are taken. Of course, there is problematic instances of those as well, and I've discussed some of that in the book. But the bigger problem on a day-to-day basis and there's research done that the GDP of this country has contracted because of delays in judicial decisions. There is virtually no sanctity of contract because if someone breaches a contract, there's precious little you can do about it. You can't go back to court and say that, look, so-and-so breached the contract and get compensation. You need to get that interim order that you can get of some kind of a stay and an injunction. But if you go about asking for damages, sorry, bad luck, because that decision will come 20, 30 years. So then that puts a premium on breaking a contract and then negotiating. So to stop that happening, the rich and privileged will go to arbitration and the rest of the country will go into a kind of some shadow mechanism. But even arbitrations are not exactly solving everything because once you get an arbitral award, again the matter will go first in a section 34, then in the appeal, then to the Supreme Court, challenged at various levels. At some level or the other, the award is set aside. And some of those awards need to be set aside. I think the deference that we give to arbitral awards in India should not be just automatic. Across the world, arbitration awards have a certain sanctity because you have a certain quality of arbitrators. That is not always the case in India. You don't always have the highest quality of judges making a decision on arbitrations. You often have technical personnel, or you have very questionable people who make those decisions. So this immunity from arbitral awards is difficult. And that's why courts often don't give them that immunity and then interfere. And then, of course, while the contract, you get some kind of a decree, ultimately it's challenged all the way up. And again, that's bogged down in the judicial system. So the delay in the delivery justice system, I think, is one of the biggest problem for our economy. And it skews how businesses function. You try to be risk averse and you introduce all kinds of clauses in a contract, each of which has a transaction cost. It is not a purely commercial transaction anymore with costs and benefits flowing for business purposes. But there are legal and externalities and legal costs, etc., that then come and distort the market, which in any case, of course, is distorted. And we have a very poor regulatory regime. That is a different topic altogether. But theoretically, the courts could step in and do some part of that regulation. But that's also completely non-existent. I don't blame the judges for this. I do, however, blame virtually everybody in it. So judges must constantly highlight this fact. I believe they do. For that, they need to have Chief Justice's conference more regularly, where they should bring this up. They don't have that often enough. The executive needs to step in and sanction more money. Parliament needs to simplify the Code of Civil Procedure. It's a 1976 code amended in 2003. India of 2023 does not need a law 50 years old. a procedural code of 50 years old.
And Evidence Act, which is a mess for many of the things we're talking about.
Absolutely. And instead what they're doing is amending the criminal procedure code, which worries me because criminal procedure code still embodies some of the rights for an accused. That's not immediately the concern. I think that's not the only concern. You need to expedite matters. You need to appoint judges and you need to simplify procedures. And neither of those two things are happening.
So is that not happening because we're in this kind of institutional stalemate, or is it just not in the interest of judges to do all this everyday boring mundane work? We want exciting cases. All the judges I see, they want to do the things that actually don't really belong in their realm. We want to talk about the environment. We want to talk about clearing beggars off of Tilak Marg. These are the things which are before the court twice a week. We have days dedicated to this kind of legislating and governing from the bench. Which of the two is it really? Because I think a lot of things could be done were they not busy doing all other useless things.
It's not that. I think they would, if they felt they had the power to appoint more judges, they would have gone ahead and done that. But that's now it's constitutional doctrine that at least in the higher judiciary, you can't issue a mandamus to increase judge strength or indeed appoint certain people other than the collegium system.
Fair enough.
Power does not belong to the judges. Equally, of course, they could direct more appointment of judges in the trial courts. But if you do appoint judges in the trial courts, where will they sit? You can have 1,000 district court judges who will be appointed. But if you have that one building with 5 rooms, you're not going to have tents outside the building. So you cannot have a solution to this problem by the judges alone. This needs to be a coordinated effort between all three. The parliament, as I said, for the procedure.
Yeah, and then the budget.
The budget for it. The money has to come from there because while personnel is the kind of a back-end operation that the courts can do, in terms of creation of that judicial infrastructure, in terms of the physical infrastructure, that has to come from the executive and the legislature. And I think in this, all parties are failing the Indian public, really. Yeah. So that's something that needs to change.
Yeah, it's a lack of state capacity building, and it's not in anyone's interest or radar to build state capacity. The final arc that I see, and please tell me if I'm reading too much in trying to pull the two books together, I feel like the overarching theme in both is that India is now at a point, either because of the queer community's rights to be rooted in the individual or in a post-liberalization society, that we need to move to a system of individual rights, property, consent, contract, and choice. So that to me is the overarching theme that's coming from both books. If there's a normative case to be made, am I just once again reading too much of what I believe into all the cases that you've pulled together, or is this where you're headed?
Absolutely. I want to put the state into the closet. We've all been there long enough. I think it's time that they know their boundaries and the courts enforce those boundaries. In constitutionalism, there is a belief that a constitution is not just about boundaries. It's about creating those institutions as well. But that's true, but it's also about those boundaries. And I think the state has just been making creeping acquisitions, to use some terminology in the securities world. And the courts have been willing participants in that. A, by failing to tell them when they are wrongfully creeping into the domain of individual rights, but also being themselves agents in enabling that by the judgments and putting those extra regulations in, for instance, the environment matters that come. It's important that in the single window clearance regime idea that we also have courts as a single window regime which only decide whether someone is right or wrong, exceeds or does not exceed. And for that, I think that needs to happen. And the state needs to go back to its original position and do what the Constitution intended it to do. Govern, but be limited by the fundamental rights. You can have the vision of the directive principles of state policy. Those are good ideals. But you cannot sacrifice the individual at the altar of the greater public good. That is not allowed by a Kantian ideology, and that is not allowed by our constitutional philosophy either. Because you can't start sacrificing people and then hope to have a happy society for the minorities or a progressive economic institution as well. So I think the links that you are drawing are obviously links that I personally believe in. Ultimately, I'm the one who's the sutradhar of the two books. So that is my judicial philosophy, and my political philosophy is the limited role of the state. I think the the court being only a negative institution, I think that's now, it's difficult to bring back. So they will obviously do. But still, I think there is scope for restraining the overreach of the government, and the courts have to be a lot more willing to step in and stop excess. And that will only happen when they stop them seeing themselves as participants in this greater cause of nation building. That's not the job of the courts.
Yeah, no, I think you've put it wonderfully. But thank you so much for doing this. This was such a pleasure, and I'm looking forward to your next book. And I have all my fingers and toes crossed for what is the outcome of the marriage equality case. And thank you.
No, thank you for having me, Shruti. And really, ultimately, a lot of these conversations, it's not as though I just give gyan and leave. I go back and reflect on what I have said, what you have asked me. And it's not as though one's thoughts are ever completely ossified. Yeah. I know my views have changed on a lot of things. Maybe because they were not fully baked by the time I have spouted them. I don't think so, but people change, ideas changed, and information inputs like this also help me in recalibrating, if not revising my position.
No, I'm happy to hear that, and I'm happy to be part of this journey and have you back every time you work on a new book.
Thanks, Shruti.
Ideas of India is produced by the Mercatus Center at George Mason University. If you enjoy this podcast, please subscribe on Apple Podcasts, Spotify, or your favorite podcast app. Help us grow by giving us a rating and leaving a review. Follow us on Twitter at @SRajagopalan and at Ideas of India. Also check out our initiative commemorating 30 years of India's market reforms at the 1991project.com.